Good morning to all of you. Welcome to Legal Matters by Sai Baba Sankara. This is for final year students. Friends, today we are going to discuss the part C, that is question papers in 2013 question paper 2013. So since the time is limited, I will speedily give you the answers. So go through first question number 15. The Bar Council makes rules requiring 75% compulsory attendance for LLB. So is the rule valid or not? Normally, you will be in this connection. I want to tell you, you will be getting questions of this type. Bar Council fixes the age limit of 20 years for 5-year students, 45 years for 3-year students. Is it valid? Or attendance, is it valid? So I will club these two and tell you. Normally you will get regarding the age restriction. So age restriction, very famous case. Indian Council of Legal Aid and Advice. Indian Council of Legal Aid and Advice versus Bar Council of India 1995. Actually in that case, the Honorable Supreme Court of India gave stay orders, and of course it is being continued. So they said it is violative of Article 14, that is equality, and also Article 19, freedom to prosecute any profession, any trade, like that, any study. So there is a famous case law. Another case law is Rishabh Duggar versus I think Bar Council of India or Union of India. I am not able to remember correctly. I think Bar Council of India 2019. He challenged Clause 28 of Schedule 3 of the Legal Education Rules 2008, which state that the age limit for 5-year students is 20 and for 3-year students is 45. I think it was 30 years. So he says it is violative of Article 14, 19 and 21. Yes, Supreme Court agreed and they have given stay orders. And the third case is Samreen Arif versus the Kolkata University 2008. Actually here what happened, this boy was allowed to appear for the LLB entrance examination, but he passed, his result was not declared based on this clause 28 since he has crossed the so-called 20 years. So at that time, the court stated that the eligibility should have been checked before allowing him for the entrance examination, not now. Therefore, you have to give a seat and let him pursue studies. After the decision of the court, then we will see. Like that they have come. So this is regarding age restriction. Now our main point is attendance. Yes, 75%. Yes, according to university education rules, there should be a minimum 75% attendance for the students to appear for the examination. You know that there is a leverage. If you are able to satisfy the concerned officer and if you pay the condonation fee, definitely you will be allowed. But anyway, here the main point is whether 75% attendance is compulsory or not. Yes, definitely compulsory. Please remember, in this connection, there is a very famous case law. Of course, it is not related to legal studies, but other. So anyway, we will discuss the case first. Ankita Meera versus University of Delhi 2018. Yeah, this is regarding LLB. Since that woman was pregnant. Rule 12 of the Legal Education Rules of BCA says that the candidate should have 70% of attendance to appear for the semester examinations. 70, I'm sorry, not 75, right? 70% attendance is necessary for even to appear for the semester examination. You may be knowing, every 6 months there will be a semester examination, right? Here Ankita Meera, she says that she was married in 2016 and later she became pregnant and gave birth to a baby boy on 22/12/2018. Right? She was married in 2016. This case came in 2018. So she gave birth to a baby boy. Due to advanced stage of pregnancy and also delivery of the boy, she could not attend the second semester because she fell short of the attendance. Now her attendance is 49%. So university did not allow her. Right? Please remember the remarks of the court. Court held that law students should prosecute law by attending the classes regularly. They should study, they should attend the classes regularly. If any health problem is there, okay, they can inform the authorities, they can take leave. Without leave, no mercy can be shown. She has to appear at least in the next semester only, not now. So, very good decision. Therefore, please remember, 100% attendance is necessary. Okay, then question number 16. An advocate wrote a letter to the union minister. So, to send cases to him. Is it professional misconduct or not? 100% professional misconduct. So, Rule 36, what does it say? Soliciting, advertising, publishing is totally prohibited in the legal profession. So, please remember Rule 36, study the rule. Then I will tell you the case law. In the matter of A, an advocate, 1961. So, actually, they do not want to disclose the name of the advocate. Normally, you also know that presently, so the advocates who are in the good looks of the party in power or the present government, they get plum posts like additional PPs or Ganjan government pleaders like that. Okay, right. So normally before becoming the GP or PP, they have to move around, they have to circle before the, they have to prostrate before the so-called political powers. Ultimately, when they get the post, normally they will be happy and they will be writing congratulatory letters. Okay, previously, nowadays SMS or direct phone has come. So at that time, he has written a letter to the minister stating that I am very happy that because of your recommendation, I became the public prosecutor. So since you have been in touch with me in some cases, please send some more cases also. Definitely, it is nothing but publishing. So, Rule 30, against to Rule 36. So, in this connection, this case law is sufficient in the matter of A, an advocate, 1961. And second one is Bar Council of Maharashtra versus M.V. Dabholkar, 1995. There, they have gone to the extent of snatching the briefs. So, you should not do like that. So, M.V. Dabholkar case, very popular case. I have made a video on that also. Please look into it. And question number 17, I believe. Is it 17 or not? Let me tell you once again. Alright. As regards in the matter of A, an advocate. So, in December 1958, the advocate was enrolled. On 1/1/1961, he wrote a letter to Minister of Law, State of Maharashtra. His name is Trilok Singh Arora. So since his name should not be written, I have not written it. So he requested soliciting briefs. That too he has written on the postcard. So please remember, first when the matter was taken as a when the matter has come before the disciplinary committee, he did not agree in the first stage. Not accepted. Second stage, when the other person, when the minister said, then he accepted. But please remember, lawyers should not do like this. So this is what you have to learn from this in the matter of being an advocate. Then question number 17. So why an advocate wrote letters to co-employee of, is it same thing? Okay, anyway, this is one problem. Question number 17, I don't know which year. Wrote letters to employees of Z, a woman employee of central government holding she was unchaste. Z has nothing to do with the legal profession. Z wants to take action. So this advocate has written some imputation against Z, who is not at all concerned with the legal profession. Can she file a case? Definitely it comes under misconduct. So the issue is whether an advocate can impute chastity, unchastity to an employee of the central government. So please remember, definitely it is a misconduct. Section 35 of the Advocates Act deals with the powers for the Bar Council to take disciplinary action against such misconduct. That's why misconduct is not defined. Please remember. What are the legal ethics? Please remember, I told you in the legal ethics, the fundamental principle, you have to maintain the honor. You have to continue the respect or dignity of the legal profession, right? So, according to Rule 35, the advocate should do his best efforts to to carry out all legitimate promises to the opposite party. So here Z is the opposite party. She is working with the central government, but she is not concerned with the legal profession. Then he said she is unchaste. I don't know whether a cross-examination he asked her or not. But anyway, Z is not connected. So therefore, it comes under professional misconduct. Straight away to say it comes under defamation, is it not? Straight away she can file the defamation as he has imputed her, he has written letters imputing her chastity. Right? Please remember. Case laws. In the case of S. Gnan Singh versus Ram Bhuja Lal, 1959, the advocate made allegations on the impartiality of the judge, which was taken as contempt. Normally, they will be doing that. This is a peculiar case. So, as regards defamation, please remember, section 500 deals with the defamation. So, please remember, it will be punished for 2 years. In this defamation again, we could throw Ramjet Malani versus Subramanian Swamy, 2006. So, please remember. So, conclusion. Based on the above suggestions and cited case laws, we will advise Z to file a defamation case against the advocate Y, or she can file a complaint to the Bar Council of the concerned state, who will take disciplinary action against him. So, this is question number 16. Then question 17. 18. A, an advocate made the complainant X to sign some documents. Okay? Signing as bail papers. Oh, here this case. Yeah. So, X is facing death sentence. Taking advantage of their being in jail, then he has taken their signatures, converted them into GPA and sold away the property. So thus he misappropriated the same. Now, the original complainant, that is the person who is the owner of the property, after coming up from jail, he wants to proceed against the advocate. Yes, he came to you, this man came to you and asked you to take action against the advocate. Yes, 100% it comes under professional misconduct. The issue here is whether the advocate can take advantage of his legal profession and cheat the client and misappropriate his property. So, Rule 22. Rule 22 says advocate shall not directly or indirectly bid or purchase either in his own name or for his own benefit or any other person known to him. Please remember. Of course, advocate can purchase the property in case he takes permission from the court. And secondly, if it is not under litigation, if it is not, yes, definitely, he is like an ordinary man, he can purchase the property. So, very famous case, PD Gupta versus Ramurthy, 1998. Always will be citing. So, PD Gupta has actually accepted a case regarding that woman, regarding that will, and that woman said that she is the legal heir. So, he filed a case under section 125 of the Hindu Succession Act. And ultimately, actually, the original heirs, Ramurthy and others, they contested the matter. While the matter is pending, the woman disposed of the property to this advocate, who in turn sold away to another third party. And ultimately, when the matter came actually on behalf, or it was disposed on behalf of Ramurthy, there is no property. So, the advocate actually got signed the documents, he purchased the property at a throwaway price and disposed of them to the third party at a higher price. This is nothing but against misconduct against rule number 22. Right? Second case, Vikas Deshpande versus Bar Council of India and others, 2002. So here what he has done is almost question similar to So this advocate, he is Vikas Deshpande, he actually went to Erawada jail, this is in Maharashtra, and contacted Ramachandra, Jonathan and two others, okay, the Vikas Deshpande, so many other persons, Vikas Deshpande is an advocate. He went to Ramarao Chandra Janardhan and others, these Maharashtrian names, they were convicted, 6 others, they were convicted and for life sentence, they were in Erawada jail. So he went to them, he said that he will obtain bail to them, he asked them to sign on some papers saying that they are bail papers, they signed all the same, but he converted the same into GPA. Then he disposed of their property. Okay, to this extent it's okay. But once again, he went to the jail and he said that you have to dispose your property, they have to procure so much of surety for these cases. And then they realized, what is the selling of property, what is that you have done? Then ultimately, after coming out bail, they came to know that already the property has been sold and he wanted to knock away the extra property also. Then they filed a petition to the Bar Council, and 100%, even though he went to the Supreme Court, not accept. It is taken as a professional misconduct. So the Supreme Court also held it as professional misconduct. So 15 minutes, one paper is over. So friends, whenever I find time, I will be coming on YouTube and giving you the questions. So please read them. So these case laws may be applicable in other question papers also. Right? Thank you very much.